Good afternoon, ladies and gentlemen. Our webinar is going to begin. My name is Steve Love. I'm President, CEO of the Dallas-Fort Worth Hospital Council. We want to thank each of you for taking time out of your busy schedule to join us for this educational webinar. And it's hosted in coordination with Hall Renda, who's an associate member and a year-round sponsor of the Hospital Council, and they've been supportive of us for many years, and we do appreciate it. Today's topic is Texas law, new limits on restrictive covenants in healthcare. And we've been looking forward to this presentation. We've got two excellent speakers from Hall Renda, attorneys Robin Sheridan, and Robin resides in Milwaukee, and Keith Duggar, who I think many of you know as he is here in Dallas and has been in the Dallas area for a number of years. Chapter 15 of the Texas Business and Commercial Code has required that non-solicitation and non-compete agreements for all employees be limited to reasonable time, the geographic and scope of the activity parameters. But on June 20th, 2025, our Governor Greg Abbott, signed into law Senate Bill number 1318, dramatically amending the state's restrictions on restrictive covenants for physicians and other healthcare practitioners. Today, we're going to discuss these changes and what it might mean in North Texas healthcare. A final note before I turn it over to our speakers: if you have questions, please put them in the question box or the chat box. And when the presentation concludes, Robin and Keith will try to answer those questions for you. And so now it's my privilege to turn the webinar over to Robin Sheridan. Welcome, Robin.
Thanks, Steve, and welcome everyone. Thanks for joining us this afternoon. It's our pleasure to talk with the group about restrictive covenants in healthcare in Texas. You have for a long time, as Steve mentioned, had state law that governed restrictive covenants, but recently that law has been enhanced, particularly with respect to healthcare providers. And so Keith and I today will take a few minutes and address changes to physicians and changes to other healthcare providers. They aren't the same. They overlap in a number of ways, but they aren't identical. So we're going to start today just with sort of a general conception of what a restrictive covenant is. I mean, essentially, it's a provision in an agreement that restricts the actions of the person or the entity that's the topic of the contract. We see restrictive covenants generally in real estate a lot. Will they apply to things like what color you can paint your house and how many tenants you can have in a building? But today's focus is going to be on restrictive covenants in employment. So restrictive covenants on the employment, from the employment perspective, are permitted to the extent that they reasonably protect the trade secrets, the customer relationships of the business. But another consideration that we always raise when we're talking about restrictive covenants is employee turnover. Because restrictive covenants will both impact increases and decreases in employee turnover. And it's a consideration that we don't want employers to miss as we talk about the legal aspects. The common types of restrictive covenants, and probably the most discussed portion, are non-compete agreements. In healthcare, we see non-compete agreements primarily in executive employment agreements, as well as for providers. And they'll prevent employees from doing particular work for a specified period within a defined geographic area. Those are really the three reasonableness parameters that Steve referenced at the introduction, that to be enforceable, A non-compete has to speak specifically to that employee's particular work or their duties. It has to be limited to a specific period of time, and it has to be limited to a reasonable geographic area. As we'll talk in a moment, the Texas law has given us more parameters and restricted sort of this criteria even further. The other kind of restrictive covenant we see often in employment are non-solicitation agreements. Those are the provisions that prevent employees from recruiting their coworkers to leave with them to go to your competitors. It's also the provision that prohibits them from soliciting patients or vendors or clients to go to these subsequent employers. Together, non-compete and non-solicitation agreements are the focus of the new law in Texas we're talking about this afternoon. A third type of restrictive covenant is a confidentiality agreement, or sometimes it's called a non-disclosure agreement. These agreements, confidentiality and NDAs, are not within the restrictions of the new law. We'll talk about that with some specificity in a little bit. But from the onset, keep in mind that while we've gotten additional restrictions for non-competes and non-solicitations, we might be able to use confidentiality agreements to pick up some of that gap that's left or to further enhance protections for our business. Side note I wanted to mention, very recently, as of September 1st, actually, there was another new law in Texas which bars enforcement of an NDA that prevents a person from disclosing an act of sexual abuse or related facts. Not relevant to our discussion this afternoon, but I wanted just to mention that while confidentiality agreements are outside of the scope of today's new law that we're talking about, there are some changes to confidentiality agreements you'll want to be aware of as you continue to include those in your employment agreements. So considerations generally for restrictive covenants, are they going to be enforceable? Are we going to be able to enforce them when the employee leaves and actually get some bang for our buck? There's employee considerations, of course. Is this going to impact our recruitment? Or is a potential candidate going to turn us down because our covenants are too restrictive? And there, of course, are employer considerations. Does it do the job? Does it protect us? And sort of the flip side of that, I encourage clients to consider as well. And that is, will we enforce it? Sometimes we get in the position where we're happy to see a particular employee leave the organization. They have become a cancer or a problem, and I shouldn't say we want them, but we are not unhappy that they are leaving the organization. And I'll often get the question of, we don't want to enforce our non-compete. We want to help them move out. And frankly, we don't care if they work for our competitor because they're such a nightmare. There are potentially negative consequences to not enforcing your restrictive covenants consistently. And so as you draft them, keep that in mind. Specifically, with respect to enforceability, as we sort of already discussed this afternoon, restriction covenants are not always enforceable. Doesn't matter if you have the written agreement that's signed and dated by your representatives and the employee, even it has been reviewed by employees' individual attorney and approved there. If it doesn't meet the reasonableness standards and the law of the state of Texas, it's not going to be enforceable. The factors we've really already talked about, the employee's actual role and duties. And when I talk about actual role and duties, particularly with respect to healthcare, I'm talking about specialization. So we are unlikely to be able to enforce a non-compete against a physician that they can't practice medicine, even if it's within a reasonable geographic area and for a reasonable amount of time. Instead, the restriction needs to be that emergency room physician can't work as an emergency physician in the reasonable area and for the reasonable period as defined. considerations for employees, let's make sure they understand. Let's avoid legalese as much as possible in those restrictive covenants, and realize that the more complex we make it, or the more likely it will end up in their personal lawyer's hand, which will make just negotiations a lot more difficult for everyone. And our consideration as employers, compliance with the law, of course, protection of our businesses, and the potential impact on recruitment. So now really getting into the meat of things and the new Texas law. Changes were effective September 1st. So any agreements that you had in place prior to September 1st, so long as they met those reasonableness restrictions of the prior law, and the prior law, I should say, they should be fine. It's only for new agreements going into effect after September 1st. There are some questions as to whether an auto-renewing agreement that renews after September 1st is grandfathered or is covered by this new law. And we expect to see some more guidance from the state in the next few months that will clear up some of those remaining questions for us. So one nice limit to be aware of is these changes are limited to the practice of medicine. So it has been made very clear the physicians who are managing or directing medical services, who are filling an administrative capacity for you, are not covered by the new law. What it means, I think, as a practical matter, is employment agreements and restrictive covenant agreements that you do going forward for those physicians in dual roles, the ones who they have a practice, but they're also serving as your IT champion or your medical director of a department or a medical staff executive. You're going to want to contract those up either separately or sort of bifurcate the restrictive covenant portions of those employment agreements so that you can meet the new law requirements with respect to the practice of medicine part, the patient-facing practice. But if you want more protection for the organization, breaking out the administrative side, it's where you can have restrictive covenant provisions that aren't as strict as required by the law. So talking about the physician restrictions particularly, what we've done is kind of gone through, broken the new law apart, and to show you what the previous law was and what the changes are in the new law as of September 1st. So one of the key considerations for some time has been that the covenant has to be ancillary to or part of an otherwise enforceable agreement. That has been the case for some time. That requirement is still in place. There is not a change to it. What it means for you is oftentimes employment at will relationships are not considered to be an otherwise enforceable agreement. The case law in Texas is kind of all over the board on this question. And so we encourage that the restrictive covenants be part of an employment agreement, just a provision in the employment agreement, so that the otherwise enforceable agreement requirement is clearly set forth in writing. As we mentioned a couple times now, the law has always required that the covenant contain reasonable geographic time and scope of activity restrictions. The changes effective September 1 is that the geographic restriction part is now limited to 5 miles or less of the primary practice site prior to termination. So the primary site prior to termination is not necessarily going to be the primary site as addressed in the employment agreement. As you hire someone and over time you have changes in staffing, their location changes. And so the record in the employment side with respect to the primary location. When it changes, I think it'll be important to record that so that we don't have disputes at the end of the day about what the primary practice location of the provider is. It's limited now to 5 miles or less. We don't have reasonableness, which is to some degree very unfortunate because, as we all know, the reasonable commuting distance for a patient in a rural area is very different than an urban area. But there are no distinctions in the new law that apply that reasonableness factor to the geographic parameter. So it's 5 miles or less, irrespective of where in the state you're located. Previously, we had to provide the former employee physician access to a list of their patients within 1 year of termination. There's no change to that. We are still required to provide that list. And we always had to provide access to the medical records of the physician's patients with upon authorization of the patient. Of course, there's no change to that requirement as well. And similarly, we've always had some protection that the access to the list is limited to the format in which we keep the record. So we've not been in a position of having to sort of climb any obstacle about finding agreements on what sort of form this access is going to be given, and we still have that protection. But whereas a buyout has been required historically, now we have a set requirement for the amount of the buyout. And you know, this is, I think, good and bad, depending on your perspective, of course. Historically, it was a reasonable price. And so we could mutually agree with the departing physician what a reasonable price for the physician or for the buyout was. And if a physician is reasonable, it was and you know, a benefit. And if they were not reasonable, then it was an obstacle. Now we know exactly what reasonable price means. There's no debate on it any longer. And it's an amount not greater than the physician's total annual salary and wages at the time of termination. Unfortunately, we don't know more about what that means. So if your physician is paid a salary, that's pretty straightforward. If, however, they're paid on collections or some sort of productions formula, we don't know exactly how we are supposed to calculate that. I don't expect we're going to get more direction, except as case law develops over time. And so as we've thought about this for clients, we've somewhat concluded that so long as you take a consistent, reasonable approach, it should be sufficient until we have additional guidelines. So in other words, if it's the average of the last 12 months of income, or it's the amount in the last 12 months, or the average of the last 2 years, like some objective calculation, it should be sufficient to cover it. We've always been restricted that we can't make the physician cut off continuing care to an acute illness. And that has not changed. But there are some additional requirements. So we have, in addition to the 5-mile geographic restriction, we have a 1-year time period restriction. So any where you might have traditionally done 2-year covenants not to compete, we're limited to a 1 year now. So 1 year anniversary from the date the contract ends or employment's terminated. There's a technical new requirement, that conditions must be written, clear and conspicuous. That has quite honestly always been the case, even though it's articulated new in the new law. But probably one of the most, I think, maybe burdensome requirements is that an otherwise enforceable covenant is void if the physician is discharged without good cause. And good cause is defined as a reasonable basis based on the physician's conduct on the job or otherwise. So think about your problem physicians that historically, we would often take the position of we will terminate with notice without good cause. It's a provision in their employment agreement. It's as non-adversarial as physician terminations can get usually. And so that would be a way that we could give notice, give written advance notice, meet the contract parameters, protect ourselves from contract action. And it really had nothing to do with the enforcement otherwise of the contract. Now, if that would be a without good cause termination that would void the non-compete. So in order to keep the non-compete in place, I think we're going to have to move to mutual agreement separations in those difficult physician circumstances. And getting mutual agreement might push us into more separation agreements, and more separation agreements means consideration for separation agreements or severance pay, covered COBRA, other kinds of consideration paid to the physician in exchange for getting this agreement. And so not only is this new law impacting the front end of employment and our employment contracts, but it's going to impact how we separate from physicians many times as well. Oops, that went the wrong way. There we go. So in addition to physicians, dentists, physician assistants, nurses, and these other practice group of nurses also have some new parameters and new restrictions on non-competes. But I'm going to let Keith talk to you about that.
Thanks, Robin. Appreciate it. And thanks for the really informative first part of this to build up on what we do with other healthcare practitioners, which is, first, I kind of want to briefly point out, as Robin mentioned, the other healthcare practitioners applies to dentists, professional vocational nurses, and physician assistants. Interestingly enough, it doesn't apply to other forms or types of licensed practitioners, such as chiropractors, physical therapists, optometrists. There's a longer list. So that says to me that this was really a facility-based change in the law, because it is typically your physicians and then your nurses and physician assistants. I guess dentists were feeling lonely or something and wanted to be included, but note that there is a finite number of practitioners to which these updated rules or law applies. But I do want to talk a little bit about how the requirements are different for these covered practitioners than they were under the previous version of the law. Interestingly enough, the previous law really didn't reference any of the other healthcare practitioners. They were just part of the general requirement that covenants had to be ancillary to or part of an otherwise enforceable agreement at the time the agreement is made. There's no change in this law about that. And Robin, next slide, please. So what are the differences in the scope of the restrictive covenants that apply to these other healthcare practitioners? Again, I'm kind of repeating what Robin said, but a covenant was enforceable if it contained limitations which were reasonable as to time, geographical area, and scope of activity to be restrained, and that covenant did not impose a greater restraint than was necessary to protect goodwill or the other business interests. That was tried and true through common law, through case law, in the sense that if someone felt like a covenant was too restrictive, they would go to court and have the judge or jury define whether the amount of time, the geographic area, the scope of the activity, whether any of those standards were not met. If they weren't, throw the restrictive covenant out. If they were, keep it in. So we kind of learned, again, I think Robin mentioned it a little bit ago, that generally up to 2 years had been deemed sufficient. geographic areas, depending upon the location within the state, sometimes 10 miles, sometimes 25 miles. And the scope of activity, I think, really had related to what the practitioner was doing and making sure that it wasn't saying if you're a PA that you can't go out and own an ice cream shop or something like that. But it really, the differences here are, under the new law, are that the scope of the activity still has to be reasonable. But you'll see a covenant is subject to additional conditions and restrictions which aren't addressed in the law and that are somewhat similar to the physician covenant. That includes the 5 mile or less radius restriction that the law imposes. And so just like with physicians, for the other healthcare practitioners covered, that geographic area must now be 5 miles or less from the practitioner's primary practice location, where they were practicing immediately prior to the contracted or employment termination. Robin, next slide. To Robin's point, I think that there, in particularly with respect to mid-level practitioners as opposed to physicians, the inclination of an employer to have those mid-levels practice at different locations than when they started out, and the potential that those practitioners practice at multiple locations as opposed to just a single. So when we talk about primary, I would generally say we're thinking about 51% of the time. But if you have multiple locations that are more than 2, and they're all about 30, 33, if it's 3 of them, something like that, it can lead to some questions about how, whether we have picked the right location. So it's really important to document where those individuals are practicing and keep that up to date so that you have your best argument when you go to enforce that covenant. A buyout must be included with the buyout payment set in an amount not greater than a practitioner's total annual salary and wages at the time of termination. Again, I at least up to now, I don't think you're seeing as much of a collections-based compensation for mid-levels. Certainly you could do that to some extent, particularly those mid-levels who are working independently, but you may have a little bit more of an idea of what that total amount is because they might have more of a set or at least a calculable annual compensation. That covenant can't be for a term longer than 1 year. Again, very similar to, in fact, identical to physician restrictions, and it does kind of define for you what that reasonable time period is if you want to look at it from the previous statutory language. And what that means, again, is that since it can't be longer than a year, the covenant has to expire no later than the 1-year anniversary of the date that the contract or employment was terminated. And like physicians, all terms and conditions of the covenant must be written, clear, and conspicuous. Robin, next slide, please. So I want to kind of talk through with you for both physicians and non-physicians. I want you to understand the changes in laws for physicians were very similar to non-physicians, but contained additional provisions that don't apply to the non-physicians. So, for example, for the non-physician practitioners, the requirements that allow for continuing care and access to medical lists or patient lists and medical records, that wasn't extended to the non-physician practitioners. So if you do have a practitioner, a mid-level practitioner who practice somewhat independently, obviously they always have to do that under the supervision of a delegating physician, but if they had somewhat of an independent practice, they're not entitled to those records per se under this law. Likewise, the covenants that apply to these non-physician practitioners, they're not void if that employment or contract is involuntarily terminated without good cause. So in that instance, there's actually more flexibility for an employer who is engaging mid-level practitioners that are covered by the statute to continue to apply that covenant, even if that individual was terminated without good cause, maybe on a 90-day without cause termination provision or otherwise. I do want to note that these changes apply only to covenants entered into or renewed after September 1st, 2025. That's repeating what Robin had said. There are, I think that there are questions as to what happens if you've got an auto renewal agreement. Is it in and of itself renewed if it does it automatically after September 1st, or is it considered part of the original contract? But I do want to turn it over to Robert now to discuss a few practical takeaways, and hopefully we can close the loop on any of these questions for you on this matter.
Thanks, Keith. So we always try to end with some practical takeaways. And we put together some things here from our experience with clients, but certainly would appreciate any input you all had as well in terms of how you see it impacting your business. So probably the most obvious, we really encourage you to review the terms of your non-solution, non-compete agreements. That it is, as a practical matter, probably your employment agreements, and templates that you're using for new employees and contractors in Texas. So historically, the courts of Texas have found that these restrictive covenant provisions that are sometimes addressed from an employment perspective in the law apply to independent contractors as well. So if you have independent contractor agreements with physicians, for example, that you're entering into going forward, you're going to want to make sure that those non-competes, non-solicitations meet the new standards. Obviously, you want to look at that from the perspective of the new law, particularly with respect to, the 1-year limit, the 5-mile limit. We want to include those words about the calculation of the buyout, because obviously we won't know what the salary is upon termination when we enter into the agreement on the front end. So we want to mirror that language a lot so that we're sure we're complying. You are probably going to have policies, contractor guidelines, handbook provisions, maybe even like internal policies, codes of conduct that are going to need to be revised to meet the new standard. Keep in mind, as we talked about earlier, that those new requirements don't apply to administrative services. So those folks with dual roles, do you, as you contract with them going forward, do you do separate agreements? Do you bifurcate like different the provisions into these rules for the administrative side and these for the like practice side? Job descriptions, to the extent they also contain any kind of restrictive covenant in the description, you want to make sure those are revised as well. As we talked about at some length a little earlier, the for-cause termination provisions in employment agreements, we know we're going to have to cross that bridge for those who are under contract already. So a question then becomes, do we want to rethink how we define for cause in the future agreements in anticipation of the use? So is there a way to address mutual agreement separation up front? Is there, what do we think about our advance notice in not-for-cause separations? What kind of written notice that we have traditionally required? Do we want to rethink that given these new limitations? Additional policies to think about that maybe already inform or that sort of arise on the fly. So what I'm thinking of, for example, is reduction in force policies. Oftentimes when we have to go through a RIF, we're going to set out parameters for how we're going to address the reduction. And oftentimes we use the not-for-cause provisions in those reductions. Maybe we want to rethink how we do that in order to circumvent, not in a nasty way, but in a, in contemplation of these new provisions. Similarly, separation agreement templates may need to be revised. You probably don't want to rely on the not for good cause separation fallback as we have for quite a long time. Leased worker and independent contractor agreements, same considerations as we've already talked about. And keep your eye out for pending legislative efforts. We're going to see court decisions. They're going to clarify some of this, possibly in interpretations that are more restrictive and possibly interpretations that are less restrictive than we might imagine. So we want to keep an eye on how the courts are viewing the standards so that we can stay current in our application. And we have any questions, Steve?
Yeah, if you have a question, please put it in the Q&A and chat. And while we're waiting on people to do that, Robin and Keith, thank you. A great presentation. I've got a couple of questions I want to ask. You know, I read this week where the FTC dropped its lawsuit to revitalize the Biden administration's ban on non-competes. Does that mean the new Texas law is dead in the water?
Keith, I'll take that one if you want.
Sure.
So you all might remember that actually it was a little more than a year ago now, the previous administration, actually much more than a year ago now, boy, time flies. The Biden administration's Department of Labor and Federal Trade Commission was doing a lot of work to limit non-competes. And at one point, the FTC actually put out guidance that would have been a ban on non-competes essentially across the country. And as those rules were rolled out, a number of courts took issue with them, and there was a stay in place. So the rules were not able to be implemented. And so it was held up in court, so to speak, and the FTC had filed an appeal to the decision that had sort of invalidated, for lack of a better word, that ban on non-competes. Well, last week, I think, or earlier this week, the FTC withdrew its appeal. In other words, it said we are not going to fight this any longer. The Biden administration ban on non-competes is gone. We're not going to try to get it implemented. But that doesn't mean that the FTC isn't enforcing non-compete rules that generally are state laws across the country. And in fact, the FTC took a California, I think it was a pet cemetery, to task very, very recently in the last few days, finding that their non-competes were overly broad and not reasonable and in violation of their state law. And so were anti-competitive and so could not be enforced. And so to answer your question, Steve, no, the FTC withdrawal of its appeal does not impact the Texas state law at all. And it simply tells us that at this time anyway, there is no potential federal ban of non-competes, but instead we're going to continue to defer to our state law.
Great. Thanks for clearing that up. We had a question in the chat box, but Chris answered it. People wanted to know if they were going to get a recording of the webinar, and yes, people that registered will. I have another question for you and Keith. You know, you mentioned the new law doesn't apply to administrative roles. Does that mean we can dust off our old non-compete and use it for, say, a medical director?
That's an interesting question. I love it. I think and I'm going to kind of be the first responder on this and let Robin clean up anything that she feels like wasn't addressed. But we are big fans of not dusting off anything. It's really taking a look at it anew. Now, to your point and what Robin talked about earlier, that for administrative positions, these rules don't apply themselves, but we certainly want to be looking at this and be mindful of all the changes that are going on, both state and federally. So while the old non-compete may be a good place to start. We highly recommend that you work with your in-house counsel, and if you don't have in-house counsel, work with outside counsel to make sure that you're not setting yourself up for significant litigation expenses that go along with that. I also want to kind of point out that we didn't really address it in here. I hope it was fairly evident, but the law specifically states that it doesn't apply to a physician's business ownership. So for those listening who have joint ventured ambulatory surgery centers, joint ventured hospitals, or anything else where physicians are owners of those ventures, you can effectively carry on with those non-restrictive covenants that you may have in there. This really relates to the employment or contracting for professional services.
Yeah, that's a really good point, Keith. I've looked at some of our attendees, and I think we do have some that have joint ventures with physicians. So that's a very good point. So you're saying they can continue with what they have in place. Did I hear you correctly?
That's right. This law does not impact those. Now, again, as with any restrictive covenant, that covenant needs to be reasonable as to time, geographic scope, and the scope of the activity. But from what I've seen, generally, clients in the area have done a very good job of making sure that their non-competes are within a protected area.
You know, this may be kind of a elementary question, but does the new law apply only to employed practitioners, or does it include independent contractors?
It covers independent contractors, although I will tell you there are certain parts of the new law that really use employment terms. We are taking the position that it applies to independent contractors because of the court decisions historically in Texas that have applied the standards of restrictive covenants to independent contractors just as they have employees. So we didn't see anything that suggested otherwise, in spite of some of this like muddy language. And I wanted to just make a quick comment on the previous question about administrative exception. And that's just really probably an operational one. And that is, with our physician shortage, I am seeing less and less physicians that really are in strictly administrative roles. It is few and far between that your medical director of a department or someone filling a medical staff role or a champion of a technological area kind of thing isn't also like seeing patients on clinic on Tuesday afternoons, because that's when you have the gap. And so if they have any kind of a patient practice, you'll want to make sure you address both.
Yeah, that's a great point, Robin. And sometimes that can be accomplished by having separate agreements for the various activities, or it can be by carefully crafting the language to specifically exclude those administrative services. The other thing, and I want to just piggyback also off of Robin's comments on the independent contractor, we've interpreted it that way to include an independent contractor. And it makes sense in a state like Texas, where we have a very strong corporate practice of medicine that prohibits employment except by a limited number of entity types. And so there's potentially a lot more in Texas than in other states of independent contracting of physicians for professional services, as opposed to those administrative services that we were talking about. So I think with all of that, exactly what Robin said, and also understanding how medicine is practiced and how how it's structured in Texas, we think it's very safe to assume that these, notwithstanding that they use some employment type terms in the statute, that these provisions apply both to employment and independent contractor contexts.
Great. Hey, we have a question that's been submitted through chat. I'm still unclear on how we handle auto renewals. For example, if an auto renewal occurs after September 1, do we need to amend and update new language?
Robin, why don't you give your opinion first, and then I'll, if I have a different thought, I'll
Sure.
come in.
Well, that's a really good question.
Mhm.
Um, it's not entirely clear. Um, and I guess what I would think is the most sort of practical answer would be when that time comes, when you come up to your first auto renewal, check with counsel to see if we have any additional directives. Do we have any information out that we've seen interpretations that tell us that? The an auto renewal is a unique thing in terms of it's very standard in contracts, right? Just about all of our service agreements and vendor contracts and things will auto renew, and our employment agreements will. And we do it very intentionally because we don't want a contract to lapse, right? We want sort of continuity of enforcement. And so from that perspective, we would expect the interpretation to be an auto renewal is not a triggering event for the new law because it auto renews, it brings continuity. It is not a juncture where the parties are negotiating anything. Now, is that how the court's going to interpret it down the pike? I'm going to let Keith take that one. But I think keeping sort of targeting it, in other words, expressly contemplating it when you come up to your first auto renewal is probably the safest bet at this point.
Yeah, Robin, I would jump in there and say I absolutely agree. In fact, I've got clients who are making the decision to go ahead and just apply it to everyone. This amends the terms of a contract, but it doesn't necessarily amend it. And in fact, it doesn't amend it in a way that is problematic for a physician. So one of the ways you can do this is just reflect as whether we call it a policy or just an enforcement intent that the organization is going to comply with the law that exists there. And a lot of reasons that people will go ahead and assume that auto renewal is a renewal for purpose of the statute is you don't want to be too far down the road and have different physicians treated differently, particularly when when the new law is far enough in the rearview mirror that they are all roughly situated similarly. You don't want to have different enforcement patterns or different enforcement provisions. And so it's just for ease of administration that I think clients will probably end up taking that position. But I'll reiterate what Robin said. I think that it is the reasonable interpretation to say that a renewal, however occurring, whether you both sign a document and physically renew the agreement or whether it auto renews, it's a renewal and the statute references renewal. So,
Right. Go ahead.
Taking that just a little further, Keith. I think you raised a really good point about like the consistency between employees, right? That and for the organization not to have like different measures for different folks. I think something we're going to really want to think about, and I can't tell you this question has been posed to me is how do we approach so that we don't want to open all those contracts to renegotiation? So it's not that we want to amend, right? Because the last thing we want to do is put forth, right, an amendment to the physician that he takes to his attorney that suddenly becomes a renegotiation of, 16 paragraphs and not just the updating for the purposes of compliance with the law. So I guess I would encourage folks that are listening, when you get to that place, consult with your counsel and see sort of how we might do that. How do we assure consistency? How do we not get too far down the path? divergent. But how do we avoid opening every one of these contracts up to renegotiation?
Yeah, good
Good.
point.
Yeah, good points. The next question I have, it's a little dangerous. It's been over 20 years, Keith. You know this since I've worked in a hospital. But y'all did a great job explaining the new buyout cap definition of total annual salary and wages. But let's look at real life. Sometimes physicians have paid collections. How does that apply then?
So I think, again, I will take a stab at this, and Robin is our Texas employment lawyer. I'm going to let her clean me up if I say anything wrong. From my perspective, I think it depends upon how long the physician has been employed. I think that my recommendation would be to start planning now for what your policy is on how you're going to treat those, how you're going to calculate that. For physicians who have been employed less than a year, my question would be, are we allowed to estimate based upon collections up to that point and create a prorated annual compensation that they would have received? For those who have been there for over a year, then I think Robin mentioned, do you just take the immediate previous 12 months worth of comp and use that? Do you take an average? So for example, if somebody had been employed for 3 years, in the first year they made 150,000, in the second year they made 500,000, and in the third year they made 250,000. Can you take an average of that? Do you have to take the last 12 months? I think there are still a lot of unanswered questions, but I think it would behoove employers to begin thinking now about what their policy is going to be on that. And then it may take us getting some additional regulatory guidance on this from the state, or getting the cases that go through a court to see what those outcomes are. And Robin, I'll be glad to have you jump in there.
Yeah, I really don't have anything to add. I think Keith is absolutely right. We're going to need some guidance. And in the meantime, we take a reasonable approach. And that should not be problematic.
Okay, we don't have any other questions pending, so I'm going to take the liberty of asking kind of the final question. Let me give you an example. Let's say an employer may have breached the employment contract, and they breached it because they did not give the advance notice of termination that the agreement required. Can they still enforce the non-compete?
Well, that's a great question. That brings
Yep.
a couple of different things into it. Robin, I'll defer to you on this. But
Sure. Yeah, unfortunately, no. Texas courts have been pretty clear that an employer who breaches the agreement, or a party who breaches the agreement, doesn't have enforceability rights. So if we as the employer breached, if we're required to give 90 days written notice prior to a termination and we didn't give it, if we didn't pay according to, the contract provisions, if we cut benefits, if we, I've had challenges where we have a calculation for RVUs in the contract, and we change the calculation, but we don't amend the contract to reflect the changed calculation. If there is a breach, you will not be able to enforce the non-compete.
Well, that was a very clear-cut answer. Thank you, Robin. Keith and Robin, this has been fun. It's been great, wonderful educational information. I'm going to give you the last word if you have any closing comments before we adjourn this webinar.
Yeah, Robin did the yeoman's work on this and is our employment law expert, so I'm going to let her have the very last word. I just wanted to thank everybody for letting us provide some information on this new law. As we've mentioned several times, it is new, and so there will be more updates in the future. We just don't know when those will happen. We will do everything we can to keep you informed of it, and if you ever have any questions, just please let us know.
Absolutely. And I will echo Keith, thanks. Always appreciate having time with the council and with you all, their members. I am in Milwaukee now, but in case you're wondering, like, what on earth I have to do with this? I spent a good part of my adult life in Texas. And so am licensed there and continue to try to stay attached to the state. Once a Texan, always a Texan, right? So thank you all.
Yeah, but Robin, you are in Milwaukee, and it looks like the Brewers are definitely going to the playoffs.
That is,
Yeah.
well, yes, we're hoping today is a better day against the Rangers than the last 2 days have been. But yes, sorry.
Yeah, the
I am a
Rangers
Brewer fan now.
are trying to be the spoiler.
Yes.
We want
yes.
to thank everyone for participating in this educational webinar. We really thank Robin, and we thank Keith. It's been great information. And we want to thank all of you for once again tuning in for a webinar as we continue to try to look at current topics and bring in experts to help give you the information to help you as you deal with these types of issues on a daily basis. With that said, we're concluding the webinar, and please have a good afternoon.
Thanks, everyone.